Here, I'm going to continue our discussion about Model Rule 1.13. In the first video, I covered the first section of this very long rule about lawyers representing organizational clients. That is, some type of corporate entity, whether it's a business or a nonprofit. Now, remember that a lawyer could be working as in-house counsel, which means you're a full-time employee of the entity, and the entity is the lawyer's only client, or the lawyer might be outside counsel, either for a smaller business or nonprofit, or maybe to handle a specialized legal task like a big lawsuit for a large organization. I call this part of Rule 1.13 up the chain of command, because here we're focusing on sections B through E of the rule that deal with the hierarchy in organizations. Section B is really long. It's a long run-on sentence, actually. So try to follow along while I read it, and then I will unpack it for you provision by provision. It says, if a lawyer for an organization knows that an officer, employee, or other person associated with the organization is engaged in an action, or intends to act, or refuses to act in a matter related to the representation that is a violation of a legal obligation to the organization, or a violation of law that reasonably might be imputed to the organization, and it's likely to result in substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. I know that was kind of a mouthful. Let's keep going. Unless the lawyer reasonably believes that it is not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. Let's consider the chain of command for a fictional entity, the Springfield School District that's portrayed in the Simpsons TV show. The bottom tier, we would have the lowest level employees of the school, like groundskeeper Willie, the school teacher Edna Krabappel, and the unfriendly lunch server named Doris. We could also have included someone like Otto, the bus driver, in this bottom tier. These individuals would be employees of the Springfield Elementary School, but they don't really make policy decisions on behalf of the entire school, at least not outside their specific job. Above them, we have Principal Skinner, who is the immediate supervisor or boss of the people in the bottom tier. And then above Principal Skinner is the superintendent of the entire school district, Superintendent Chalmers. So if you're a lawyer for the school district, suppose you discover that groundskeeper Willie is doing something illegal or something dangerous that could create serious liability for the school, which would actually be in character if you've watched the show. Willie is a little eccentric and impulsive. In this scenario, the lawyer would first try to reason with Willie to resolve the problem. But if that proves unsuccessful, the lawyer should go up the chain one step at a time. First to Principal Skinner, and if he is not responsive, then to Superintendent Chalmers. The point of Section B of this rule is that normally the lawyer should not skip steps and go straight to the top, as tempting as that might be. Go up the chain of command one step at a time. If a lawyer skips steps, in theory, you could have situations where the lawyer is actually subject to discipline. Next example, let's talk about a fictional corporation, Dunder Mifflin. This is from the TV show The Office, a kind of familiar sitcom. Suppose the lawyer encounters a legal issue for the company with something unlawful or dangerous that Dwight Schrute is doing. Again, this would be pretty typical for his character. Now, I have him portrayed at the lowest level with Jim as his supervisor. But if you've watched this series, you know that there was an ongoing argument for several episodes between them about which one was higher than the other, the assistant regional manager or the assistant to the regional manager. I picked this example because it's actually something lawyers routinely encounter in practice. Some roles or positions within the corporate hierarchy may be clearly defined, while others are a little unclear. And this confusion could be at the lowest levels. For example, is a legal assistant higher or lower than a paralegal? Or at the top level, like is the chief operating officer higher or lower than the chief financial officer? Or are they equal? It's not always clear to the lawyer in practice. So when you're practicing law, you should be aware that this is not always apparent and it can present problems for the lawyer. Suppose, for example, you represent a large state university. Is the bursar higher or lower than the ombudsman or the comptroller for the university system? Sometimes it's clear, but sometimes it can be tough to ascertain their relative rank for purposes of this rule. Now, suppose we get past Dwight and Jim at Dunder Mifflin, and neither of them have been responsive to the lawyer's warnings and admonitions, so we get to their immediate supervisor, Michael Scott, who basically manages the Scranton office for this company. That part is pretty clear. But suppose Michael Scott is also uncooperative with the lawyer, and then the next step in theory is the VP immediately above that regional manager. Well, if you watch a few seasons of this show, you know that this changes. For a while, this was a character named Ryan, and later on, it was a woman named Jan. And this illustrates another challenge for lawyers because sometimes there's a lot of turnover at one tier in the corporate hierarchy, and the lawyers may have trouble keeping up to date on the changes in personnel and knowing who's responsible for what or who you would have to go to with a problem. Now, above this top-level manager is a top-level manager at the corporate headquarters. And so let's say it's eventually you get to the president or CEO. Who's above that? Well, for most corporations, it's the board of directors is the very top of the chain of command. Keep in mind, however, that there are government regulatory agencies to whom a board of directors must answer on certain legal issues. And that's going to become important in a later section of this rule. But just keep that in mind. For the entity itself, the board is usually the very top of the corporate hierarchy, but they are not unaccountable. I think you get the basic idea for now. Now, let's talk about some of the official ABA comments related to Section B of Rule 1.13. Comment 4 says, in some circumstances, it may be appropriate for the lawyer to ask the constituent to reconsider the matter. So let's give an example where a client actually heeds the lawyer's advice. So suppose you're talking to, let's say, a mid-level manager, and the person misunderstands the law initially, but then they accept the lawyer's advice. Then the lawyer in that situation could reasonably conclude that the best interest of the organization does not require that the matter be referred to a higher authority. If you have an MPRE question about this rule, and this is one of your answer options, where the lawyer talks to a lower level employee about the potential problem, and then that person responds positively, that's probably the right answer to the test question. There's no need to escalate the matter in that case. So the proper thing is for the lawyer to drop it if the problem has already been resolved with the individual involved. Now, what if you have a defiant constituent? This comment continues. If a constituent persists in conduct contrary to the lawyer's advice, it will be necessary for the lawyer to bring the matter to the attention of the next higher authority in the organization. So you're going to go up the chain of command, as I've been explaining, but you're going to probably do it one step at a time. Now, are there some extreme cases where the lawyer should just skip the problem person? Yes, but this is the exception, not the norm. And so the comments continue. If the matter is of sufficient seriousness and importance or urgency to the organization, referral to a higher authority in the organization may be necessary, even if the lawyer has not communicated with the constituent, the individual involved. So let's say a low-level employee is doing or has done something that could result in fatalities, let's say, or an emergency intervention is necessary right away, or the problem person is temporarily unavailable because they're on vacation or traveling for business. The lawyer may need to skip that step in order to protect the entity's legal interests. Again, that would be the exception, not the rule. That concludes our overview of Section B of Rule 1.13. Now, let's move on to Section C of Rule 1.13. And here we're going to be talking about the top of the chain of command or the board of directors. Section C is basically our whistleblower rule. It says, except as provided in paragraph D, if 1, despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or a refusal to act that is clearly a violation of law. And again, we're talking about the board has ignored the lawyer and continues with serious illegal conduct. The lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization. Then the lawyer may reveal information relating to the representation, whether or not Rule 1.6 permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. So if the lawyer went up the chain of command, like Section B of this rule requires, but the board of directors, let's say, laughs off the lawyer's warnings, the lawyer knows that this situation could pose devastating consequences for the entity itself. Remember, the entity is a client. Then the lawyer may have to preemptively go to the relevant government authorities to have them launch an investigation or intervention, in the hopes that this will be better for the entity in the end than if the lawyer just waits for the government to discover it on their own. So maybe if there's an intervention sooner, the damage could be mitigated or there will be less severe consequences. Maybe the entity can be salvaged if the lawyer does this right away. This is an extreme scenario, one that fortunately occurs only rarely in practice, but it does happen and you should be aware of it. And you will also need to know about this step for purposes of test questions. And as I said, this means that the lawyer essentially becomes the whistleblower. And in practice, you should be aware that this will probably be interpreted as a serious betrayal by the board of directors and managers, and the lawyer will be terminated at that point and probably accused of lying or exaggerating the problem. Or they may even blame the lawyer for the problem that the lawyer is reporting to the authorities. So Section D adds an important caveat to Section C for certain specific scenarios. It says that paragraph C shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law or to defend the organization or an officer or employee or other constituent associated with the organization against a claim arising out of an alleged violation of the law. So if the government is already investigating potential violations, we could be talking about here the Securities and Exchange Commission or the Federal Trade Commission or the EPA or even the National Labor Relations Board. Or maybe there's a private lawsuit from another private party against the company, and the corporation has asked the lawyer to defend it. The lawyer would not need to preemptively tattle or become a whistleblower. We already know about the problem. The problem is already known to outsiders. This would also be true if the lawyer is hired, let's say, to conduct an internal audit to determine the potential scope of the liability for the board, while the lawsuit or government investigation is still in its preliminary stages. This is very common. In either case, Section C no longer applies. This means it would not be proper, in that case, for the lawyer to divulge confidential information to outsiders, and the lawyer could be subject to discipline, in that case, for doing so. This can require sometimes a difficult judgment call. Now, let's move on to Section E. It's about what happens after you've been fired for being a whistleblower. So sometimes when you talk to the original wrongdoer in an organization, let's suppose it's a mid-level manager in the company, they respond by getting you fired immediately before you can go up the chain of command. And Section E covers this situation where the lawyer suddenly is no longer representing the entity because the lawyer flagged a problematic issue internally. This could be a scenario where the lawyer has to withdraw immediately because realizes the wrongdoer has been using the lawyer's services to perpetrate a crime or a fraud. In any case, Section E says, a lawyer who reasonably believes that he or she has been discharged because of the lawyer's actions taken pursuant to paragraphs B or C, or who withdraws under circumstances that require or permit the lawyer to take action under either of those paragraphs. The lawyer shall proceed as the lawyer reasonably believes necessary to assure the organization's highest authority is informed of the lawyer's discharge or withdrawal. So this is basically the lawyer's farewell letter. Suppose you confront the corporate president or VP who hired you, and they immediately fire you and have you escorted from the building. You still have a lingering duty to do one more thing to protect the entity itself. Remember, the entity was your client, even if the manager there had the power to hire and fire you as the entity's lawyer. So if a reasonable lawyer would conclude that the entity is in peril unless the higher-ups or the board intervene, now you have an obligation to, or a duty to notify the board of directors about the problem and the unfortunate circumstances of your termination or withdrawal. Note that Section E may apply even if you have not gone up the chain of command step by step, as would normally be required under Section B. The lawyer cannot go up the chain if the representation has ended abruptly. In fact, the lawyer may be barred from the premises in this type of case. So as a departing warning, the lawyer then must skip all the way to the top and basically put the board of directors on notice about what is going on and that the lawyer can no longer do anything about it. So why do we have this requirement? Because sometimes that bad apple of a manager, the type of person who gets caught doing something illegal and just fires the lawyer for even bringing it up, that type of person is also likely to hide what really happened from the board or their superiors. They'll either lie to the board and say the lawyer was fired or quit for some other reason, or the board members might not even find out the lawyer was fired until the next board of directors meeting, and that honestly could be months away. So it's important for the lawyer to provide notice in the meantime. Okay, one last comment before we wrap up this part of the rule. Comment 9 to Rule 1.13 is about how to apply the rule to government lawyers. It's a little confusing. It says Rule 1.13 applies to lawyers in governmental organizations. And for example, it says if the action or failure to act involves the head of a bureau, either the department of which the bureau is a part or the relevant branch of government may be the client for purposes of Rule 1.13. Well, that's not very clear. It says they may be the client, which means they may not. But the point is, if the lawyer is able to determine the entity of a government that constitutes the client, the lawyer should follow the chain of command rules in sections B through E to the extent possible. But you should be aware that for government lawyers, this is sometimes unclear. This concludes our discussion of sections B through E of Rule 1.13. In our next video, we'll talk about the remaining sections of the rule.